morning and welcome to the February 2024 docket of the Nashville docket of the Tennessee Supreme Court. Welcome to all of you on live stream. We've got a couple of interesting cases today and we're looking forward to them. I want to say quickly that we're just especially pleased to have our colleague Jeff Bivens here in person. Just had some much needed knee surgery and doing great, and so we're especially pleased to have him here with us. So those of you who have not been here before, 30 minutes per argument. Appellants reserve time for rebuttal. All right. Are there any preliminary matters before we begin? All right. Mr. Hibner, you may call the first case.
Robert E. Lee Flade versus City of Shelbyville, Tennessee et al.
Good morning, Your Honors. May it please the Court, Daniel Horowitz of the Nashville Bar, on behalf of Appellant Stephanie Isaacs. I'm here today with my co-counsel Melissa Dix, as well as the BCLP's counsel Sarah Martin. We've ceded 3 minutes to Mr. Harbison. With the Court's permission, I would like to reserve 3 minutes for rebuttal, please. Thank you. This case is about how the Tennessee Public Participation Act, or the TPPA, interacts with Tennessee Rule of Civil Procedure 41.01. More broadly, though, this case is about whether the most vulnerable speakers in this state, those who cannot afford to hire an attorney to represent them, will be able to secure legal representation or instead be forced to bow to baseless litigation threats and submit to censorship simply because they cannot afford the expense of litigation. Before I jump into the legal issues presented here, I do want to highlight the facts underlying this case, which are egregious. Back in December 2020, plaintiff Robert E. Lee Flade wanted 2 tenants out of his property. As a result, according to paragraph 6 of his complaint, he instructed his tenants, quote, they would be required to promptly move. Now, there were some issues with this. For one thing, it was during the middle of COVID, so there was a federal eviction moratorium in place. For another, it was the middle of winter, and Mr. Flade was violating his legal obligations to his tenants, one of whom was a young child, by failing to provide them with functioning heat and water. When tenant advocates...
sorry, but since the facts are not especially relevant to the legal issues that are before the court, I'm hoping we can move to the legal arguments that you're making about, the interplay between the TPPA. If I could just ask a question in
Yes.
that regard. So I know you have 3 arguments. You have, your first argument is that just based on the text of the voluntary dismissal rule, this is a statute that the voluntary dismissal rule is subject to. And then you have the implied vested right argument, and then you have the counterclaim argument. So let's start with your first argument. Can you point me to the language in the TPPA that you contend conflicts with or sort of overrides the voluntary dismissal rule such that a plaintiff would not be able to voluntarily dismiss his or her lawsuit?
Just to clarify that, we don't say that the TPPA overrides the voluntary dismissal rule. What we're saying is that the rules are compatible. So you get to take a voluntary non-suit, but the court also adjudicates the TPPA petition. That's how Rule 11 motions are treated, and we think that these are not in conflict, so there is no incompatibility there. But the language from the statute, so the statute begins with a statement of enacted purpose and intent, right, about protecting First Amendment rights and about, at the same time, protecting the right to file meritorious claims for demonstrable injury, and then construing the statute broadly to effectuate those purposes. Later on, refers to the statute as a substantive remedy, right, that goes beyond, that supplements the rules of civil procedure. So for all of those reasons, certainly the language subject to the provisions of any statute is much broader than the panel said it was here, and the TPPA's affirmative rights, substantive remedies, and the fact that they supplement the rules of civil procedure, I think certainly must be, Rule 41 is subject to the provisions of the TPPA.
So what are, we have this language subject to any statute. What other sorts of statutes would satisfy, whatever the bar is in your view for either modifying or overriding the Rule 4101.
So again, I don't think we are modifying. I don't think we are overriding. I think Rule 41 and adjudicating a TPPA petition post non-suit are compatible with one another. I do recognize that there are some statutes that have said, you know, this is expressly exempt from Rule 41 and non-suit cannot be taken here, but those are not the only circumstances in which the subject to language should come into play. And the reason I say that, Your Honor, is because there is a specific statute, at least one, Tennessee Code Annotated Section 20-6-301A. That provision addresses when a plaintiff voluntarily dismisses an action while a counterclaim is pending for contractual attorney's fees. It also refers to a defendant who asks for attorney's fees as a counterclaimant. Certainly that statute, right, is, Rule 41 is subject to a statute like that. But again, you know, this subject to language, it doesn't say subject to a statute that contains an express exemption, that explicitly states that Rule 41 does not apply here. It just says subject to, right? Which is
the rules that are mentioned there, you know, so it says subject to, and it lists several rules, and then it says, or any statute. So the rules that are listed, 2305, 2306, and 66, I mean, they contain very specific language. So saying that certain actions shall not be voluntarily dismissed without approval of court. So it's very clear from those rules, you know, how they interact with 4101. I mean, this is different. You're really relying on more of a kind of an implication from the overall structure and purposes of this statute, aren't you?
I think it's a lot better than an implication, right? So Section 2017-109 expressly states that the TPPA supplements any remedies which are otherwise available under the Tennessee Rules of Civil Procedure. I don't know what that could mean otherwise if you're not going beyond.
Well, it could mean that it's not the exclusive remedy. In other words, you don't, you know, a plaintiff doesn't have to pursue his or her attorney's fees and sanctions, et cetera, under the TPPA to the exclusion of any other remedies that may be available that may have pre-existed the TPPA.
Or other counterclaims or any other actions by that party.
I'm sorry?
I said such as additional counterclaims, additional remedies, even the additional causes of action.
And that's fair, except the statute also says the TPPA shall be construed broadly to effectuate its purposes and intent, and that matters a great deal because the TPPA's enacted purposes and intent would not only be frustrated by allowing strategic non-suits to defeat the TPPA's otherwise mandatory remedies, they would be eviscerated, right?
But there are two purposes. I mean, the statute itself lays out really kind of competing purposes. I mean, there's the purpose of preventing the chilling of speech, but there's also, I mean, the text actually, you know, says that another purpose is to, trying to find the language, it's to, you know, to also kind of encourage or protect, oh, here it is, protect the rights of individuals to file meritorious lawsuits.
And I'm glad you raised that because I think our interpretation of this statute fulfills both purposes, whereas the panel's fulfills neither. So let me drill down on that, right? The panel emphasized that Section 2017-102, which you've just referred to, reflects what they call the TPPA's twofold purpose. So first, we have the bit about encouraging and safeguarding First Amendment rights, but then second, at the same time, protect the rights of persons to file meritorious lawsuits for demonstrable injury, the key words being meritorious and demonstrable. Now, the panel suggested that allowing courts to adjudicate TPPA petitions after a non-suit would undermine that second statutory purpose. That is wrong. Allowing courts to adjudicate TPPA petitions after a non-suit does not threaten meritorious lawsuits for demonstrable injury in any way. It only threatens non-meritorious lawsuits for imaginary injuries, which is what we have here. Based on the panel's ruling, though, trial courts are forbidden from distinguishing between meritorious and non-meritorious lawsuits because after a non-suit, the panel held that they can't examine the merits of a plaintiff's claims at all. That outcome is not compatible with either one of the TPPA's enacted purposes, and the panel was wrong to suggest it was. So this language about meritorious lawsuits and demonstrable injury supports our view here, right? How do you determine that something is meritorious and the injury is demonstrable if we are forbidding courts from examining the merits at all?
But let me follow up, if I may, on Justice Campbell's original question. Are you saying that the question that's before us requires us to construe the TPPA?
Certainly in part, yes. I think that's right.
Okay, if so, what language are you asking us to construe specifically? Not arm waving on the purpose, but specifically, what language are you asking us to interpret?
Yes, so the TPPA lays out this specialized dismissal procedure, right? So there's the initial burden of a petitioner to show that that they were sued in response to a matter, or for speech regarding a matter of public concern. And then there is a 3-step process under that statute. Step 1, I gotta meet my burden, but step 2, if I do,
Which section are you referring to and which provisions?
sorry, Your Honor, one moment. I believe it's, I wanna say 105A. I will get it for you. Yes, TCA section 2017-105, A, B, and then C. So that's the 3-step process there. I've got to meet my initial burden, but then afterward, and this is the key portion of the statute, if the petitioning party meets this burden, the court shall dismiss the legal action unless the responding party establishes a prima facie case for each essential claim, element of the claim in the legal action. There is no non-suit exception in that provision. There is no safe harbor provision in that section of the statute. That differs from Rule 11. This is more robust.
Are you asking us to infer then from the absence of language, or are you asking us to construe? I'm asking you to point me to what is the language. If we are going to construe a statute, then I have to look at the words that you're asking
Yes.
us to construe. That's what I want you to point me toward.
and
I
the-
understand the overall purposes, all of that, but textually, what text are you asking us to?
We are simply asking you to apply this provision as written, to not create or infer a non-suit exception to this mandatory dismissal if a petitioning party meets their burden and a responding party does not.
All right, but in this case, we're talking about a dismissal before any burdens were met.
Well, I don't know that that is,
The trial court had not made any finding that the burdens were met. So tell me what specific language in the statute supports what you are saying.
so I do want to flag the fact that it's true the trial court did not make a finding that the burdens were met, but the plaintiff also conceded that this was speech regarding a matter of public concern. I can get you the concession. I believe it's 130 to 131 of the record and 157 of the record, where he said he does not dispute.
Okay, are you asking us to construe then the language on whether a party has met his burden
No,
to include this situation before there's been a trial court determination?
No.
Am I understanding you correctly?
that is not what we're
All right,
asking you to do.
back to my original question. Point me to the text that you are asking us to find supports your construction.
So it is that provision that I just read. So I want you to construe that provision not to include a non-suit exception. It does not exist in there. And I want you to construe that in the context of the statute's instruction that you must construe the TPPA broadly. To
All right,
affect-
so we're looking at 105, which subsection are
B.
you looking at?
105B. If the petitioning party meets this burden.
Meets this burden.
Yes.
So are you asking us to construe the language meets this burden
No.
to include this situation?
Oh, certainly, yes, to include the situation. So
All right, so you are saying that your client, at the time of the voluntary dismissal, had met this burden?
that's correct. Or at least the court must go on to adjudicate a TPPA petition after a non-suit. Yes, Your Honor.
Mr. Horowitz, may I follow up? And I'm sorry about my raspy voice. But I think this directly relates to the discussion that you and Chief Justice Kirby just had. Would you refer, please, to 107A?
Yes, Your Honor.
Okay, so 107A says, if the court dismisses a legal action pursuant to a petition filed under this chapter. Now, how does that relate to a voluntary dismissal under Rule 41?
So you definitely don't get these remedies for a voluntary dismissal. What we're asking you to do is say that you can take your voluntary dismissal under Rule 41, but the trial court must go on to adjudicate the merits of the TPPA petition. And if granted, then certainly these remedies are mandatory. Does that make sense?
But if the petition's already been dismissed, how is it going to even apply?
So the petition has not been dismissed. The petition has not been adjudicated. It
The
certainly,
whole action has been dismissed. and
Okay.
The whole suit has been dismissed.
the action has been dismissed, the suit has been dismissed, the petition has not been adjudicated. And what we're
But
asking,
this says if the court dismisses a legal action pursuant to a petition.
Right.
If the court
That's right.
dismisses the action
And so what we're-
pursuant to the petition.
and what we're asking is this court to hold that while a Rule 41 dismissal can be taken, the court must still go on to adjudicate the TPPA petition.
But the court is never going to get to the point of dismissing the action pursuant to the TPPA.
Sure it will.
petition.
If it goes on post-non-suit to adjudicate the petition, it definitely does. And that's exactly what the Court of Appeals says is the appropriate standard in the Rule 11 context, right? That in two decisions,
Mr. Horace, let me interrupt you before you get to that. I mean, you do concede that TPPA does not mention Rule 41, voluntary non-suit.
That's
You
right.
have to imply to get there.
Well,
Aren't there, there's no uniform Public Participation Act like we have in some acts. Almost all the states around us have them now, but there's not a uniform one. And after certain court rulings, some legislatures have gone back and amended the statute to explicitly include non-suits, right?
I don't know whether that's true or not, Your Honor. I apologize. I can tell you that California and Texas, which are the statutes upon which the TPPA was based, have not seen any need to do that because they have both of their courts have held you cannot evade the consequences of this statute simply by non-suiting in response to an anti-SLAPP petition.
I guess one thing I'm struggling with is the public policy of all this. It seems that we ought to construe this in a manner that a plaintiff in the original action would want to non-suit as soon as possible to keep down litigation costs.
Well, so the plaintiff would still want to non-suit as soon as possible under our interpretation too. And we have seen that happen before the panel did what it did here, right? So as soon as you realize that your lawsuit has no chance of surviving a TPPA petition, you want to get out immediately because the longer you last, the more expensive it is going to be. So we gave you, in response to Mr. Harbison's brief, two examples of well-represented litigants who, as soon as they realized they could not overcome a TPPA petition, stipulated to the grant. You do it to avoid sanctions, and you do it because it minimizes your exposure to the other side. But certainly, if those litigants thought they could avoid a six-figure fee award just by filing a one-page notice of non-suit, they would have done that. Nobody contemplated that there was going to be this end around what were supposed to be mandatory consequences under this statute just by non-suiting. And the panel's decision, I just want to emphasize this, is so destructive to the policy of this statute. You can not only file a bogus lawsuit and run up litigation costs as much as possible until the date of a hearing once, you can do it 3 times under Rule 41's rule.
But we consider the overall purpose of the statute. I mean, we can't imagine text that supports we have to construe specific language in light of that purpose. And I still think that you appear to be asking us to make an implication from the absence of language.
Respectfully, Your Honor, it's the other way around.
Okay.
We are asking you not to imagine a non-suit exception within this statute. That is what the Court of Appeals did here. They say, absent this language that does not exist in Rule 41 about an express exemption, right, that you must construe the TPPA to have been displaced by Rule 41.
I just have to push back on that.
Okay.
Because what you are describing is not an exemption. An exemption is based on language in a statute. What I'm seeing is that it just has never gotten to the point where the trial court dismisses the action pursuant to the TPPA petition at the time of the voluntary
Respectfully, Your
dismissal.
Honor, what Rule 41 says is subject to the provisions of any statute. And then
Okay.
the TPPA has no mention about a non-suit exception. And what the Court of Appeals said was, absent an express exception written into the statute, we're going to assume that Rule 41 displaces the statutory text. But
Well,
what-
but, I mean, there's other language, if we're talking about language that's absent from the TPPA. I mean, also missing from the TPPA is any provision saying that the trial court shall adjudicate a TPPA petition, you know, under all circumstances or in any circumstances. The provision you're pointing to is really, I mean, it's the standard that the trial court has to apply when it adjudicates a TPPA petition, but it says nothing about the circumstances in which the trial court is required to adjudicate a TPPA petition.
what it says is you shall dismiss if they don't meet their burden, right? And there's not a you shall dismiss unless there's a non-suit or they don't meet their burden. It's shall dismiss if the responding party doesn't meet their burden. But
Let me ask you, just as a follow-up to that, so if you go to Rule 4101, I mean, Rule 4101 does identify one circumstance in which something that is pending in the trial court will still be adjudicated even in the event of a non-suit, right? It says in the last sentence of 4101, subsection 1, if a counterclaim has been pleaded by a defendant prior to the service upon the defendant of plaintiff's motion to dismiss, the defendant may elect to proceed on such counterclaim in the capacity of a plaintiff. And I understand that you're relying on this as well,
Yes.
sort of as an additional argument, by arguing that this is a counterclaim. So I think I understand your argument in that regard. I'm not sure that I agree with it, but to me, this sentence kind of identifying a situation where the trial court would continue on to adjudicate something actually undermines your subject to argument, at least to some degree.
I think they're consonant, but let's talk about the counterclaim exception. So our position is that the court should hold that a defendant's affirmative claims for attorney's fees and sanctions under the TPPA qualify as counterclaims. And I note this court would not be breaking any new ground if it adopts that holding. As we noted on pages 21 to 22 of our reply brief, both Tennessee statutory law and a host of Court of Appeals decisions spanning decades have characterized a defendant's claim for attorney's fees as a counterclaim without any apparent
But
controversy.
we have never held that.
Well, so I don't know that I agree with that. If you look at the court's decision in Blake, it certainly did not adopt this narrow, constricted definition of counterclaim. It was talking about failure to meet a statute of limitations, failure to give an employee notice of a workplace injury that were claims made in an answer. It certainly wasn't a countercomplaint. There were not affirmative causes of action filed, but this court adopted a broad definition of counterclaim and said that qualifies there. But
Can I ask you just one question about Blake? You know, there is some language in Blake where the court talks about, I don't have the exact language in front of me, but sort of suggests that at least there, you know, that it said that something could be, would be a counterclaim if it could be a standalone cause of action. I think there's some language to that effect. Do you read that as saying that's necessary for something to be a counterclaim, or just that that's sufficient?
I don't. I
to
think
be
Blake was
a-
interpreting the case before it and said this is an example that qualifies. But certainly what Blake did not hold is that a counterclaim is restricted to a narrow definition of a cause of action raised in a countercomplaint. There was no cause of action in Blake. There was no countercomplaint in Blake. And this court still held that the counterclaim exception applies. But I do want to, before I run out of time here, emphasize the statute, right? Tennessee Code Annotated Section 20-6-301A. That provision addresses when, quote, a plaintiff voluntarily dismisses an action while a counterclaim is pending for contractual attorney fees. It also refers to a defendant who asks for attorney's fees as a counterclaimant. The reason I flag this is because it means that statutory law, Tennessee statutory law, outside of this context, defines a defendant's claim for attorney's fees as a counterclaim not only generally, but in the specific context of a plaintiff's voluntary dismissal.
Well, let's be a little more precise, because what the statute defines as a counterclaim is a claim for contractual attorney's fees. And it seems to me that that would always kind of check the box of being something that could be a standalone cause of action.
How would
But
that be?
actually
It's a remedy.
It's a contract, but it's based on a contract.
But it's based on a contract of a fee shifting provision in a contract. You can't affirmatively say.
Well, for example, in a marital dissolution agreement, if you have to defend the marital dissolution agreement, you get fees.
That's right.
You don't have to get to a certain point. The trial court doesn't have to make any findings, basically, if it's filed.
And I agree with you. That would be a counterclaim within the meaning of this rule, but it is not a standalone cause of action that you would raise in a counter complaint.
I might disagree with you there.
You certainly could not file an original lawsuit saying you owe me fees based on the earlier litigation. It would be a remedy.
Actually, I think you could.
I believe it would be a I'm out of time now, so I don't get to respond. Thank you, Your Honor.
All right, thank you. Mr. Harbison?
Good morning, Your Honors.
You can see what you're in for, Mr. Harbison.
Well, I think I've got a little lighter load this morning.
Okay.
May it please the court, Jay Harbison from Neal and Harwell here in Nashville, and I'm in the somewhat atypical but frankly pretty fun situation of arguing as an amicus on behalf of myself. I urge this court to reverse the decision below simply because allowing plaintiffs to take a non-suit in the face of a pending anti-SLAPP petition would eliminate contingency representation of those who need competent counsel the most. My brief mainly discussed the Porter case. And my client in that case, Heaven Porter, was 21 years old. Her former employer had sued her for a variety of claims, seeking hundreds of thousands of dollars after she essentially discovered that it misled the public via supposed charitable solicitations, and she spoke out about it. She spoke out against her former employer. Ms. Porter lived paycheck to paycheck, could not possibly have afforded any lawyer. The case came to me, I looked at it, thought I think this is going to be a good case for an anti-SLAPP petition. And I took it on a contingency basis because of the mandatory fee shifting in our anti-SLAPP Act. We fully briefed an anti-SLAPP petition. We responded to a motion for additional discovery. There was also a TRO that we got dissolved. It was a lot of work, a lot of billable hours, a lot of time. Then 30 minutes before the hearing, plaintiff took a non-suit. I'd spent all day, it's a Friday morning for the hearing, I spent all day the day before getting ready for it. Plaintiff's counsel came into court, essentially waiving the opinion from this case, Flade, as a get-out-of-jail-free card. And I say all of this because I represented Ms. Porter, someone, again, who needed competent counsel the most on a contingency basis. And if this court affirms the decision below, I and many others like me will be unable to do so in the future. Allowing plaintiffs to escape the consequences of these meritless SLAPP suits is contrary, in my opinion, to the stated deterrence policy of our anti-SLAPP Act.
Wouldn't that be a great argument to the legislature?
It would be a great argument for the legislature, Your Honor, but I'm here before you today. I really do feel that the consequences of the opinion in this case are pretty dire, and I strongly suggest that they are in direct conflict with the stated legislative purpose of the Anti-SLAPP Act. Again, and this is really all I have to say about it, the opinion below will ensure, all but ensure, that future victims of SLAPP suits, like Heaven Porter, many, and in fact probably most of whom cannot afford competent counsel, will not be represented at all, and that cannot be what the legislature intended with this act. Thank you all.
Good morning, Your Honors. My name is Jason Reeves from the Bedford County Bar. I represent Mr. Flade in this action before you. Thank you for having me today. I want to get to the heart of what I think I'm hearing is the concerns that the court may have, but I want to point out first that through this, there's some common threads that Tennessee body of law carry through. For example, the plaintiff is the master of his or her complaint, Chimney Hill Condo Association versus Chow. For well over a century, plaintiffs in Tennessee have enjoyed the right to voluntarily dismiss an action without prejudice and refile the action within 1 year of the dismissal. That's the Evans v. Perkey case. It was in 1982, so we're closer to a century and a half now. The right of the plaintiff to take a non-suit is free and unrestricted, except in limited and well-defined circumstances. That's Robles v. Vanderbilt University, quoting Lacey v. Cox. Indeed, Tennessee Rules of Civil Procedure 4101 contemplates that a voluntary dismissal may be taken late in the proceedings when both parties have expended significant time and expense. And that's Adamson v. Grove from the court below recently, citing Douglas v. Lowe. The court has hit on and recognizes Rule 41 is a pretty powerful tool that is commonly and frequently used by plaintiffs throughout the state, and there's a long history of that, as I've referenced.
Mr. Reeves, let me just ask you this.
Yes, sir.
Respond to the argument that we can imply an exception to Rule 41 versus what the Court of Appeals said it has to be explicitly set out in statute.
Well, I think when you look at Rule 41, it clearly sets out certain types of rules in which it doesn't apply, 2305, 2306, and Rule 66. And it goes, you look at what the types of those rules are, and then you apply it, it says, or any statute. Well, case law, Clark v. Weather and Davis v. Ibach are both cases that talk about, those are Tennessee medical malpractice cases in which TCA 2926-122, the certificate issue was before the court. Nothing in the certificate of good faith statute expressly precludes a plaintiff from a Rule 4101 non-suit. Later it says, of any statute must refer to statutes that specifically limit a party's right to obtain a voluntary non-suit. As we've heard here today, there is nothing in the TPPA that expressly and specifically accepts it out of Rule 4101. There is no language whatsoever. Counsel wants to argue that the absence of that means that, therefore, it's an exception. That's not how it works. The absence of language, the failure to expressly put it in the statute means that Rule 41 applies to even TPPA cases. And it must be that way. Otherwise, these other cases that require it to expressly and specifically would be pointless.
I mean, isn't the language, though, they're subject to any statute? It's kind of broad. I mean, that doesn't say subject to the provisions of any statute that, specifically disallows voluntary or non-suits or something to that effect. I mean, it's a little hard to know, I guess, exactly how to interpret that. So your position is that it has to be express.
Yes, correct, and I agree with you.
Where are you getting that from the text itself?
Well, from the Rule 41, it's not there. It says or of any.
Well, where are you getting, I guess, from from Rule 4101?
That's right. It says of any statute. I completely agree with you. That's what it says, and that could be very broadly interpreted. And I think you could even, if you wanted to apply it that broadly, even in divorce cases, you could argue that.
So why shouldn't we?
Because
if that's a permissible reading of
the body of law in Tennessee clearly says that it must be expressly accepted out, and it goes into analysis of Rule 2305, 2306, Rule 66, the type of cases that those are, and it comes down to it. No, for it to be of any statute, it must expressly state it.
So it has to be similar to the rules that are mentioned there. We need to sort of read any statute.
That's correct.
In the context of these other rules that
Well,
do specifically disallow it.
Okay, but it might come up often when it's express. But how does that say that it must be express? Your opposing counsel's argument is that it is contrary to the overall purpose and structure of TPPA.
Okay.
Where do you find language that says that will not suffice?
I would point you to the entire body of case law dealing with the Tennessee Medical Malpractice Act.
I have to read the entire body of case law. Point me to a case that supports that.
And again, Clark versus Werther, Davis v. Ibach, Robles v. Vanderbilt, they all talk about this in the context of whether Tennessee Code Annotated 2926-122 is an exception to Rule 41. And every single one of them come down and say, no, it is not expressly stated that you can't overcome the failure to provide your certificate by filing a Rule 41 motion. So all of that body of cases. But I'll even go one step further and say, I'm a small town lawyer. We have to handle, many types of cases, right? It's very difficult for somebody in my shoes, if counsel's argument prevails, to know whether or not Rule 41 applies to any other statute if we apply it that broadly. In other words, it would destroy Rule 41 if we applied it so broadly that it applies to any other statute. That can't be the case. And I think that those Tennessee Medical...
Counsel, can you give us some examples? I had the same thought, but give me some examples of how Rule 41 would be destroyed if it were applied to other statutes.
Well,
or if of any statute.
Of
the
any
rule says
statute.
Of any statute.
So it would apply to everything that is a statute under our law.
A statutory cause of action under our law.
Any statutory cause of action would be eviscerated, Rule 41, the use of it, and that clearly is not the intent. That clearly is not what is meant. When you look at statutes that do exempt, and I think this was a question earlier, 20-6-301, contractual attorney fees, that makes sense. 29-3-107, substitution of realtors in forfeiture cases, nuisance type cases. 28-1-105, contractual time limitations. All of those statutes specifically and expressly say that it's an exception to Rule 41. But other statutes that don't, then it's Rule 41 is still available. The TPPA clearly fails to. And the reason this is important, I talk about the Tennessee Medical Malpractice Act, that line of cases was in the early and middle teens here in Tennessee and is well established. TPPA Act was enacted in 2019, well after. So the General Assembly had to know, it's presumed they would know, that if they wanted to accept the TPPA out of Rule 41, that is to say to prevent the filing of a voluntary non-suit and to prevent the petition to dismiss from going forward after the filing of a voluntary non-suit, they would have to expressly state it. So we have to assume because they did not expressly state it, they did not intend for it to be an exception to Rule 4101.
So let me ask you about that. Your position is the exception would have to be expressly stated.
Yes, sir.
So why does it say of any statute?
I wish I had the answer for that. It clearly means, and the court below says that refers to cases in line with 2305, 2306, 66, and statutes that specifically say it.
Counsel, let me ask you about Section 2017-102. This is the provision that states within the text of the statute itself what the purposes of the statute are and instructs that it should be construed broadly to effectuate its purposes and intent.
Yes.
So, this is a somewhat unique situation where, we're not being asked to just divine what the legislature's purposes are. I mean, the legislature has told us what the purposes are. Does that provision help you or hurt you?
That provision doesn't hurt me.
Why not?
Well, if that was the perfect opportunity. If the legislature intended to accept it out, it should have carved out Rule 41 as an exception there. And it could have done so in any number of ways. It could have done so in that language by continuing and saying that this is a vested right. That would have carved it out. They could have done so by saying that the petition to dismiss is to be considered a counterclaim. That would have carved it out. Or alternatively, they could have said that the petition to dismiss should be treated as a motion for summary judgment.
Well, are you asking us to construe it narrowly then?
I'm asking you to construe it as written and that the absence of express and specific language as required by Tennessee body of law, Rule 41 is not accepted out. Rule 41 is available to the plaintiff. Rule 41 ends the case even when a petition to dismiss has been filed but not heard and adjudicated, which is this case, which is the Solomon case. The Adamson case a little bit different because the petition to dismiss had never even been filed at the time of the non-suit. Now, oddly enough, in that case, the plaintiff on appeal argued that, well, that should be treated as a counterclaim, and that's where the counterclaim language began. And the Adamson court in dicta talked about that, which of course was rejected by both the Flade court below and Solomon courts below. And so it's the absence of express language that carries the day for plaintiffs.
So how does, if we read the TPPA in the way you're asking us to read it, how does that effectuate the purposes and intent of the TPPA?
It doesn't change it whatsoever. Those purposes and intents still apply to parties and to citizens of the state. However, everyone will be on notice after this case, if this court agrees, that Rule 41 clearly applies. Now, before this was determined, there was no body of law on the TPPA, so you didn't know, and all you could look at is what was the body of law, right? And at that point in time, the time of the filing of this case, there was every reason in the world to believe that a voluntary non-suit is allowed all the way up to and before an adjudication on that. So it doesn't change the right of parties that is set forth in the statute. All of those still apply, but it also still applies the rights of the plaintiffs, as we have a long history in the state of Tennessee to be able to take a Rule 41 non-suit. If the legislator wanted that to be an exception, they knew about it at the time, they chose not to put it in the statute. And I think one of the justices hit on that. Wouldn't that be something perfect to present to the legislature? Absolutely. If councils want this change, that's the body they should be going to.
I'd like to move, if we could, to the counterclaim argument.
Yes.
How do you define counterclaim, and why isn't this a counterclaim? And specifically, I'd like you to talk about the language in the TPPA that does call this a substantive remedy.
It does. But as the Flade court noted that I pointed out before the trial court, the TPPA does not create a private cause of action.
And so is it your position that for something to be a counterclaim, you would have to be able to pursue it as a separate cause of action?
In general terms, that is correct. There are some exceptions to that, and I think the counterclaim, you talked about it in the MDA format and things of that nature. But it has to be something more than a defensive mechanism, which is what the petition to dismiss is. It's a defensive mechanism. It's a procedural mechanism. Federal
court also, if granted, entitles the petitioner to attorney's fees and potentially sanctions, so they are getting some relief. I mean, it's not simply a way to block the affirmative suit.
Correct, but that is not an automatic right. It is not an automatic grant when raised. And it's similar to the Tennessee Medical Malpractice Act. The reason that the Court of Appeals rejected that policy argument was because the court had discretion in how to treat the failure to provide a certificate. In TPPA cases, we heard it earlier, there's a three-step process. They first have a burden to show to the court. If the court accepts that, then the plaintiff has a burden to respond, and if the plaintiff meets their burden, the case moves on. If the plaintiff fails to meet that burden, then the court can consider attorney's fees, costs, and sanctions. So it's not an automatic right to something. So if you think of it in terms of a vested right, it certainly is not a vested right. It's not ownership of property. It's not certain. It is a request of the court to speed up a quick review of the case to determine whether there are sufficient merits to allow it to move forward.
Well, I think that may explain why it's not a vested right,
Mm-hmm.
but why does that explain why it's not a counterclaim?
Well, so first of all, obviously, a party couldn't file a petition to dismiss if a previous action hadn't already been filed, right? So it's not a standalone claim. It is a response more in line with essentially an affirmative defense being raised. And the Flade case below, they talk about that as somewhat of a hybrid between a Rule 12 motion to dismiss and a Rule 56 motion for summary judgment. It's really neither of those, but it combines the procedural mechanisms of that. The point of that is there is no right there. There's no guarantee. There's no automatic outcome of it. It requires further proceedings of the court. Those further proceedings of the court are halted when a Rule 41 is filed.
Do you think that lower court decision saying that a motion for sanctions is, or treating that as a counterclaim, were correctly decided?
I think that there's some distinctions in depending on the timing of that, and I'm involved in one of those right now. And the case I'm involved in was a motion for sanctions in which the award was granted. The court found the right to sanctions, but had not yet determined the amount of the sanctions when a Rule 41 was filed. That's different than if I had simply filed a motion for sanctions and before the hearing, before the determination by the trial court, the Rule 41 motion to dismiss was filed. Just because I filed the motion doesn't guarantee me an automatic right. But once the court makes that finding, that does. Then the only question is, what's the amount of the attorney's fees? And that can be determined more administratively.
So what would your position be, and forgive me if this shows some ignorance about exactly how the TPPA petition adjudication process works, but imagine a trial court at least partially adjudicates a TPPA petition, says, yeah, I'm gonna, find that the plaintiff here has not made out, its prima facie case, but kind of holds in abeyance any determination of attorney's fees or sanctions in between the time of those two things, so after the kind of determination that the plaintiff has not made out its prima facie case, but before any adjudication of the exact amount of the attorney's fees and any sanctions has occurred, the plaintiff tries to voluntarily dismiss. Would that be permissible?
Well, I think we have to look at the guidance of Rule 41 itself, which allows for the motion, the notice of voluntary dismissal to be filed up until when? The moment that the jury is dismissed to deliberate, right? So extremely late in the proceedings. So back to TPPA, if there was a hearing held on the petition to dismiss and no ruling has been issued and a voluntary non-suit is filed, voluntary non-suit wins. If there's a hearing on the petition to dismiss and the court finds that the defendant has carried their burden, plaintiff has failed to carry their burden, and sets a later hearing for determination of sanctions and attorney's fees amounts, non-suit doesn't win that.
Because that's a vested right at
Because that
point?
creates that vested right.
So is that similar to other case law in the state where you're exactly correct about when the jury retires to deliberate, but in a non-jury case, I recall it when the first witness is called? Is that similar to what we're doing here?
Well, I think that even up to the point that a judge issues the opinion in the case, if, in other words, if a judge takes the matter under consideration and doesn't issue an opinion the day of the trial or the hearing, and before that judge issues it, then non-suit wins. There is a case, however, where a judge ruled from the bench orally what the findings were and what the outcome of the case was, but had not yet put down the order, and a non-suit was filed in between those two moments. And our Court of Appeals said, no, you can't do that. You've already, the order, the ruling of the court's already come down.
Let me ask you this. I think the word is concerned about the argument Mr. Harbison made.
Yes.
Are you asking us to create a situation where well-deserving SLAPP defendants, anti-SLAPP petitioners cannot acquire legal counsel?
No, I'm not asking that at all, and I'm suggesting to the court that that's not even the right side of the coin. The right side of the coin is a client like my client in this case, who filed a meritorious action, but because of the uniqueness, the newness of the TPPA, through the discovery process that you would otherwise be entitled to, the matter was appealed to Court of Appeals, or an application was presented to the Court of Appeals, which was denied, and then an application to this court, which was denied. And then it finally was sent back down and discovery was provided. And at that point, it was very clear the attorney's fees in this case alone would be so exorbitant that prosecuting that case further just didn't make any financial sense. So the case was non-suited. But look at where we're at. We're 2 years down the road, 2 years of further appeals. So the irony of the case is that the public policy arguments that councils are making cut against their actions in the case. The tens of thousands of dollars that have been spent on appellate record here and appellate argument here for a case that was non-suited more than 2 years ago. It's astonishing. And so for people like my client, the TPPA is being used as a sword. There are always going to be people who are on the wrong side of the law. There are always going to be people who, the way rulings come down, it may hurt their cause. We can't allow that public policy to pull on our heartstrings to make us do what the law doesn't allow us to do here. And I think that the court below talked about that. The Tennessee Medical Malpractice Act cases talked about that. The same arguments were made in those cases, public policy-wise, and the courts have rejected that and said, no, that's not what the law is. They're essentially asking you to become judicial activists. Well, the legislature didn't put this in there, didn't accept it out, but you should read it in there. No, if the legislature wants it in there, the legislature should come back and change the statute, not have judicial activism. I think that that's what I needed to say to your honors. If there's any other questions, I'd be more than happy to answer them.
You're not required to use all of your time. Thank you, counsel.
Thank you.
Mr. Horowitz, would you spend a short amount of your rebuttal time responding to the evisceration argument that we
Yes.
just heard?
Mr. Flade wants you to construe the statute in a way that permits him to do, without penalty, 3 times exactly what the statute was designed to prevent. I cannot emphasize enough just how catastrophic the consequences of the panel's ruling have been here. In practical terms, if the panel's interpretation prevails, then all of the TPPA's deterrence value would be eliminated up until the date of a hearing, and people like Mr. Flade, who filed a libel per se claim that's not even recognized by Tennessee law, criminal causes of action that are facially non-cognizable, could file SLAPP suits without incurring or even risking consequences for doing so. As a result of the panel's decision here, you are now seeing plaintiff after plaintiff follow the exact playbook that the panel blessed here by filing bogus SLAPP suits, maximizing litigation expenses for as long as possible, and then non-suiting in many cases literally minutes before hearing, half an hour before hearing in Mr. Harbison's case.
All right, I'm going to push back on that. I want to follow up on what you said earlier, that a plaintiff who files a petition and then gets a TPPA petition filed against them, that they are motivated to go ahead and do a voluntary non-suit quickly in order to reduce the legal fees. Is that really true? If I have filed a lawsuit against you, you file a TPPA petition against me, and I'm like, oh, this has just gotten to be too much, I'm going to non-suit. What you are describing is that you have to go through exactly the same amount of discovery, acquiring evidence in order to prove your TPPA petition. Don't you? I mean, you still have to prove it.
Respectfully, Your Honor, this statute is not quite as forceful as we may be imagining here. The burden is so minimal. You just got to prove prima facie element of your claims.
But you still have to do the same amount of discovery in order to get to that point. So how have I, by voluntarily dismissing, reduced the legal fees?
Respectfully, Your Honor, you do not. The statute presumptively forbids discovery. You're supposed to come to court with your
Discovery
evidence.
on the TPPA matters.
If you need it, if you got to show good cause to need it, you are supposed to come to evidence to be come to court with evidence to be able to support your claims. But if I might be able to, with the 30 seconds I have left, subject to is a lot broader than the panel defined here. Rule 41's exception in federal law does not get construed according to this express exemption language. On page 11 of our reply brief, we've called the court's attention to the Cheeks versus Freeport Pancake House. The FLSA is silent to Rule 41, but it applies. Justice Campbell, you would have to overrule the Court of Appeals decisions in Justice and Menchie, the Rule 11 cases.
Well, they're not binding on us. so
They are not binding on you, but you would have to say that courts lose all their opportunity to have a deterrence component associated with bogus litigation and to enforce Rule 11 in order to rule for the plaintiff here. There's no textual reason why Rule 11 should be treated differently from the TPPA. If anything, the TPPA should be considered a more persuasive claim because it is a statute, not one of the 3 listed rules.
Thank you, counsel, for your fine arguments. The case will be submitted. The court will take about a half-hour recess.
All rise.